Good afternoon, everyone. Uh, yes, we're afternoon. Yep, 12:04. We're going to go ahead and get started with our webinar today. I would like to welcome all of you to the Ethics Commission's second webinar in our series, Dakota Dilemmas. Today, we are looking at a practical application of conflict rules. I want to thank each of you for taking time out of your schedules today, hopefully over your lunch hour, to join us and continue learning about ethics laws through this Dakota Dilemma webinar series. I want to especially thank all of you who joined us for our earlier session in March, which was a historical exploration of ethical conflicts in North Dakota. My name is Rebecca Binstock, and I have the privilege to serve as the Executive Director for the North Dakota Ethics Commission. With me today is Logan Carpenter, who serves as General Counsel for the Commission. Mr. Carpenter and I will be co-hosting our webinar today. So this Dakota Dilemma webinar series was born from both the Ethics Commission and the legislature's recognition of the need for education about the Commission and how it meets its constitutional duties and obligations. So again, I want to thank everyone for joining us today. We're very excited to be here. Our webinar today is going to share an overview of the Commission's work with the purpose to educate those subject to the Commission's rules and the public. Our webinar is not going to address specific situations or circumstances that may arise for individuals, but we are going to explore some hypotheticals for you all to practice what you have learned through the webinar. During our previous webinar, we explored the history of ethical conflicts in our state, looking back over the past 150 years. From the tensions and corruption of the of the Dakota Territory to the modern day establishment of the Ethics Commission. During today's Dakota Dilemma webinar, we are going to focus on the state's future, of course, being mindful of our history, to discuss how we can manage ethical conflicts moving forward to ensure transparency in the important work done by our state. Please feel free to drop any questions that you may have along the way in the chat. And at the end, we will have time to answer those questions or discuss those questions during our question and answer session. We're going to wait to do that at the end of our time together. So during our first webinar, we utilized polls that pop up for you in the Teams app to solicit responses from participants, really kind of a check your knowledge type moments. We plan to do that again today. But please know that sometimes that polling function may not work. What we've learned is that on some devices, it does not work properly. And so it might depend on your device that you're on. However, if you're unable to submit a response, that's okay. We're still going to walk through what the hypothetical teaches us, and you can always respond in your head. With that, let's pick up where we left off during our last webinar and explore how potential conflicts of interest can be managed using the Commission's rules. So let's do a brief overview of our agenda for today. Our focus today is going to be on the Commission's conflict of interest rules. In 2022, the Ethics Commission adopted rules regarding conflicts of interest for public officials. These rules require public officials to disclose known potential conflicts of interest prior to the public official taking action or making a decision in a matter where the potential conflict of interest exists. So as we address and discuss these conflict of interest rules, these are the basics or the areas that we're going to focus on. So we're going to go back and we're going to review the North Dakota Constitution, Article 14. This is where the creation of the Ethics Commission happened, and we're going to talk about what that looked like. We're then going to move on and discuss the Commission's authority to promulgate or adopt rules and the process that happens when the Commission adopts rules. That's in our conflict rules section. We're then going to get to the meat of our discussion today, which is the 6-step process. This process is an overview and an outline to help you walk through the 6 steps to manage potential conflicts of interest under the commission rules. We're going to touch briefly on 2 other areas. One is legislative rules. The North Dakota legislature has adopted conflict of interest rules, and we're going to touch just briefly on those legislative conflict rules because the commission was formally asked in an advisory opinion request to review those rules. So we're going to talk a lot about that advisory opinion. And then the last thing is we're going to touch briefly on quasi-judicial rules that address the appearance of bias in quasi-judicial proceedings. These quasi-judicial rules are similar to conflict of interest rules with some key differences. So we're going to talk about those today. So let's go ahead and get started. We're going to start our session today with kind of a recap of how the Ethics Commission was established. We talked about this during our first webinar, but we really just want to establish that baseline again for today. So the Ethics Commission came from a citizen-initiated ballot measure sponsored by the North Dakotans for Public Integrity. It put Measure 1 on the general election ballot in 2018, so a few years ago. The measure established a state ethics commission in the North Dakota Constitution. Voters passed the measure by a 54 to 46% margin. And then this measure created Article 14 or added Article 14 to the state's constitution. North Dakota joins 47 other states with an independent ethics commission or another independent equivalent entity. Only 2 states in the United States don't have a government office dealing with ethics. Those 2 states are Idaho and Wyoming. Informational material that was available about Measure 1 back in 2018 focused on and emphasized that at the time, specifically referenced and talked about the commission undertaking the issue of conflicts of interest across state government. So very in line with what we're doing today or talking about today. In 2019, during the 66th legislative session, the legislature passed enabling legislation for the commission, and that sets out the procedures that apply to the commission and certain penalties that Article 14, which created the Ethics Commission and also had some other components of the Constitution, required the legislature to create. This legislation in 2019 included penalties for lobbyist gifts, lobbying by public officials, and lobbyists delivering campaign contributions. Also in 2019, the commission had its members appointed. So this occurred in the later part or middle part of 2019 after legislative session wrapped up. The Constitution requires that 5 members or 5 individuals serve on the Ethics Commission. Those individuals are appointed by the consensus agreement of the governor, Senate Majority Leader, and Senate Minority Leader. Commissioners who serve on the Ethics Commission cannot be lobbyists or other state public officials. All of our current commissioners are part of or are the original 5 commissioners who were appointed in 2019. Their first terms were staggered, and then they were each reappointed to second terms. So what's great about the commissioners that serve on the Ethics Commission is they cover a geographic or cover all of the geographic areas of North Dakota. So our chair, Paul Richard, is in Fargo. We have a vice chair, Dave Anderson, who's here at Bismarck. We have Ron Goodman in Oaks. Ron also served as the first chair of the commission. We have Dr. Cynthia Lindquist, Commissioner Dr. Cynthia Lindquist of St. Michael, North Dakota, and Ward Kozer of Williston. I believe some of our commissioners are with us today, so maybe if they have questions or comments, they can put those in the chat. In 2019, the commissioners, as the commission, they also established the mission of the North Dakota Ethics Commission. The mission of the North Dakota Ethics Commission is to strengthen the confidence of the citizens of North Dakota in their government by ensuring and promoting transparency and accountability. Now let's go back to talk about Article 14 of the Constitution for just a second in a little bit more detail. So under Article 14 of the Constitution, the Ethics Commission was granted authority to adopt ethics rules related to 4 areas. We call these our 4 buckets. 1 is transparency, 2 is corruption, 3 is elections, and 4 is lobbying. Any lobbyist, public official, or candidate for public office can be subject to these rules under Article 14. Article 14 also gave the Ethics Commission authority to investigate alleged violations of the Commission's rules, Article 14 of the Constitution, and related state laws. So to date, the Ethics Commission has adopted several groups or sets of rules. In fact, there's 4 of them. The Commission has established rules related to the complaint process, lobbyist gifts, the appearance of bias in quasi-judicial proceedings, and conflicts of interest. The complaint rules, which were adopted in 2020, these outline the process for filing and then the subsequent investigation of a complaint. Lobbyist gift rules were also adopted in 2020. These describe the prohibited gifts between lobbyists and public officials, as well as some exemptions to that prohibition on gifts. The rules related to or addressing an appearance of bias in quasi-judicial proceedings was adopted by the Commission in June of 2022. These rules address and manage the appearance of bias that can happen in quasi-judicial proceedings. The last set of rules adopted by the Commission, and the one that we're going to focus most on today, is the conflict of interest rules. These were adopted in October of 2022. And these are a baseline rule to manage potential conflicts of interest for public officials. We're going to talk about the definition of public officials shortly. But for now, we're going to say or just describe it at that. The Commission continues to work with entities that our rules impact to ensure that we have understanding and uniformity, hence why we are here today. The Commission is also currently discussing and considering financial and travel disclosure statement rules for public officials. So today, out of the 4 sets of rules that have been adopted, we are going to focus on understanding and applying conflict of interest rules in state government. After that, we're going to briefly turn and talk about quasi-judicial rules and talk about the key differences between those and general conflict of interest rules. I will note that both quasi-judicial rules and conflict of interest rules were adopted by the Commission in 2022. However, quasi-judicial rules were specifically required to be adopted by the Commission under Article 14 of the Constitution. And Article 14 gave the Commission, I believe it was a 3-year window to do that, right? 3 years? Yep. So let's talk about that rulemaking authority that was granted to the Ethics Commission in the Constitution. So the Ethics Commission is constitutionally authorized to promulgate or adopt ethics rules related to those 4 areas, as we call them the 4 buckets: transparency, corruption, elections, and lobbying, which are to be followed then by lobbyists, public officials, and candidates for public office. So understanding what this means is important to understanding the rules that are adopted. So what does this mean? We're going to go back to 2020 when the Commission was considering gift rules. In 2020, the Commission was considering the scope and the extent of gift rules. The Commission, in its consideration, requested assistance from the Attorney General when it was defining the term lobbyist, specifically asking whether the Commission could define the term lobbyist broader in its rules that it adopted, pursuant to its constitutional authority, than the statutory definition found in North Dakota Century Code 5466018. The reason that they wanted to do this was to make sure that the rules that they enacted gave effect to the entire language of Article 14. In Letter Opinion 2020 L09, the Attorney General opined that the Commission has constitutional authority to adopt a rule defining lobbyist in their proposed rules, and it can be more expansive than that statutory definition of lobbyist. The opinion noted that the statutory ethics rules, if there are any in place, which there are, and the Ethics Commission rules should be read in harmony when possible. When possible means that, according to the Attorney General opinion, when it's reasonable and workable. However, if these rules cannot be harmonized, the opinion said the constitutionally authorized rule prevails. The Attorney General's opinion in Letter Opinion 2020 L09 was based upon a North Dakota Supreme Court reasoning or case in City of Fargo versus Ruther from 1992. In the City of Fargo versus Ruther, the North Dakota Supreme Court was asked to analyze whether a statutory provision which limited the admissibility of a certain type of roadside breathalyzer test. It was called the alcohol level evaluation roadside tester, whether that conflicted with the rules of evidence that were adopted by the North Dakota Supreme Court. The North Dakota Supreme Court has constitutional authorization to adopt rules of procedure that are followed by all courts in the state. Ultimately, the court concluded that the legislatively enacted rule could be harmonized with the constitutionally enacted rule. But in that case, if the statutory rule were to engulf a constitutional rule or was in direct conflict, the constitutional rule prevails. Both Attorney General opinion, Letter Opinion 2020 L09, and the case law for the City of Fargo versus Ruther really provides that basis for how to analyze and potentially harmonize Ethics Commission adopted rules, which come from that constitutional authority, with other statutes and rules. So when the Ethics Commission has this rulemaking authority and they adopt rules, which they've done in the past, what does that process look like? This is a bit of a unique process. The Ethics Commission, as we've talked about previously, is a constitutional entity. It doesn't fall into one of the three branches of government in our state. It's also not an administrative agency. As we've previously discussed, its rulemaking authority is constitutional. It's derived from Article 14 of the Constitution. This is distinct from the source of authority for administrative agencies. Administrative agencies typically adopt rules, administrative rules, in a similar way to the Ethics Commission. The source of authority for administrative agencies is delegated to the agency by the Legislative Assembly in North Dakota. Therefore, the rulemaking process for the Ethics Commission is modified from the rulemaking process for administrative agencies. So under North Dakota Century Code 546611, the Ethics Commission is required to follow the portions of the Administrative Agencies Practice Act, which specifically apply to the Ethics Commission. The portions of the Administrative Agencies Practice Act, which specifically apply to the Ethics Commission, include languaging referencing the Ethics Commission. Typically, a rule or the legislation will say, we'll use the term agency to refer to an administrative agency or commission to refer to the Ethics Commission. The Ethics Commission under the Administrative Agencies Practice Act is subject to certain requirements. Those requirements are that the Ethics Commission must complete a regulatory analysis. It is subject to the fiscal impact statement requirement, a takings assessment requirement, and hearing, notice, comment, and publication requirements in the same way that they apply for administrative agencies. However, portions of the Administrative Agencies Practice Act do not apply to the Ethics Commission. Unlike administrative agencies, commission rules are not reviewed by the Attorney General's office or the Legislative Administrative Rules Committee before final adoption. These provisions are inapplicable because the Legislative Assembly did not or does not delegate rulemaking authority to the Ethics Commission in the same way that it delegates authority to administrative agencies. So, after all of that, what process does the Commission follow to adopt rules? So again, as I mentioned, this is a modified process from the typical administrative agency process in which agencies adopt rules. So first, the Commission prepares and finalizes a proposed rule. Then notice goes out to the public through publication in newspapers. The Commission then receives comments, holds a public hearing, responds to comments, and then finally the rule is approved by the Commission, by a vote of the Commission. Commission rules, even though they're not administrative rules, they are published in the North Dakota Administrative Rules book in Chapter 115. So as we've kind of given you an overview of the rulemaking authority and the rulemaking process, let's talk about the conflict of interest rule. And with that, I'm going to turn it over to Logan.
Thanks, Rebecca. So let's talk about the conflict of interest rules. The conflict of interest rules apply to all state public officials and walk them through the process of how to manage potential conflicts of interest when they come up during their work in state government. So you may be asking yourself, who is a public official? Well, the Constitution provides the definition in Article 14. It includes elected or appointed members of the executive and legislative branches, members of the Ethics Commission, and legislative employees. So some examples of public officials include our statewide elected officials like the governor, the attorney general, the treasurer, and the secretary of state, all legislators, members of the governor's cabinet, and members of boards and commissions, among others. It does not include executive branch employees, which is an important distinction. So when do the conflict of interest rules apply? They apply when public officials must make a decision or take action in a matter as part of their duties. This includes the day-to-day decisions of state government. Examples of that include voting on a motion during a meeting, voting on a bill in the legislature, and directing staff to take a certain action, among other examples. If you're in the context of an adversarial proceeding, you go to the quasi-judicial rules instead, which we will talk about later in the presentation. So how does a public official know when to disclose potential conflicts and how do they do it? Well, they walk through the 6-step process under the Commission's rules. So let's get an overview of that 6-step process. The process is outlined in the flowchart, which should be on your screen now. As outlined in the flowchart, there are 6 essential steps for managing a potential conflict of interest. So let's start at the top with step 1. Prior to taking action or making a decision in a matter, public officials should identify any potential conflicts they may have. Then you move to step 2. On the record, if possible, declare the potential conflict of interest. At this stage, provide enough facts for others to understand the potential conflict and what it entails. Moving into step 3, the public official has 2 options. The first option being recuse. At that point, if the public official is recusing, they should fill out and file the Commission's approved conflict of interest form. But they also have this other option under the Commission's rules. They can ask the neutral reviewer for help. So if they do that at step 3, at step 4, the neutral reviewer takes over and evaluates 5 factors under the Commission's rules in North Dakota Administrative Code, Section 115-04-01-03, subsection 7. Once you're done with step 4, you move into step 5, and the neutral reviewer does a determination at step 5 and can reach one of 2 conclusions. The neutral reviewer can determine a disqualifying conflict of interest exists. At that point, the public official will recuse, or the neutral reviewer can determine no disqualifying conflict of interest exists. At that point, the public official may participate. That completes step 5. At step 6, which is included in the bottom of the flowchart there with the step 5, the public official will fill out and file the Ethics Commission's approved conflict of interest form. So let's go ahead and walk through each of these essential steps, step by step. Step 1, identify potential conflicts. Again, prior to taking action or making a decision in a matter, a public official must identify any potential conflicts the public official has. This creates a duty for each individual public official to do a quick ethics assessment before doing his or her work. So what is a potential conflict? Well, that's defined by the Commission's rules in North Dakota Administrative Code Section 115-04-01-01. A potential conflict of interest means a public official, as part of the public official's duties, must make a decision or take action in a matter in which the public official has 1, received a gift from one of the parties, 2, a significant financial interest in one of the parties or in the outcome of the proceeding, or 3, a relationship in a private capacity with one of the parties. So let's break down the meaning of those last 2 and 3. A significant financial interest means a direct and substantial in-kind or monetary interest or its equivalent not shared by the general public. This does not include lawful campaign contributions, participation in a public employee benefits plan, or investments in a widely held investment fund, like mutual funds and exchange-traded funds. Now, relationship in a private capacity means a past or present commitment, interest, or relationship of the public official in a matter involving the public official's immediate family, individuals residing in the public official's household, the public official's employer, an employer of the public official's immediate family, or individuals the public official has a substantial and continuous business relationship with. So let's test your knowledge of step 1 of the 6-step process with a quick poll. Let me get that up for you, and it should be appearing on your screen. Poll 1. A licensing board is voting on whether to contract with a video production company to produce educational materials. Mr. Chandler Bing owns 50% of the video production company and is married to board member Monica Geller. Does Ms. Geller have a potential conflict of interest under the Commission's rules? 1, yes, it's a gift. 2, yes, it's a significant financial interest. 3, yes, it's a relationship in a private capacity, or no. Take a minute and submit your answer, and then we'll see what you all think. Give you about 20 more seconds to submit a response, if you want to. Okay, let's go ahead and close the poll. Looks like 55% of you said yes, it's a significant financial interest. 43% of you said yes, it's a relationship in a private capacity. And 1% of you said no. So let's find out the answer. The correct answer is yes, it's a relationship in a private capacity. It is an interest or relationship in a matter involving Ms. Geller's spouse, Mr. Chandler Bing. So let's assume that Ms. Geller has identified her potential conflict of interest. What does she do next? On step 2, once a potential conflict of interest is identified, the individual public official, like Ms. Geller, must disclose it. If the potential conflict comes up during a meeting, declare it on the record. This helps ensure it will make it into the minutes of the meeting. Once the public official declares the conflict, he or she must provide enough facts for others to understand the potential conflict. You need to connect the conflict to the action or decision before the public official. So picture it as if the potential conflict is the color blue and the action or decision before you is red. You must make purple by drawing the connection from the potential conflict to the action or decision so others understand it. So let's test your knowledge of this short step, step 2, with another poll. A minute to get it up here on your screen. Poll 2. Board member Jason Kelsey identifies a potential conflict of interest he has related to a decision to be made by his board. Under the commission's rules, when should Mr. Kelsey declare the potential conflict of interest? In an email prior to the meeting, in a conversation with the chair during a recess, after discussion on a motion but before the board's vote, or when the agenda item triggering the decision comes up for discussion. Please submit your answer and we'll take some time for you to get those in. See, some answers are still rolling in. We'll take about 20 more seconds so everybody can get them in if they want to. I'll note these questions are a little bit more difficult than the ones from the last webinar. Okay, let's close the poll. Looks like 76% of you said when the agenda item triggering the decision comes up for discussion. 20% of you said in an email prior to the meeting. And 4% of you said after discussion on a motion but before the board's vote. So let's reveal the correct answer. The correct answer is when the agenda item triggering the decision comes up for discussion. When it's during the meeting, it ensures that it gets in the minutes of the board. So that is the correct answer. So let's assume Mr. Kelsey declared his conflict correctly. What does he do next? So we move into step 3, 2 options to manage conflicts. After a public official has successfully disclosed a potential conflict, the public official again has two options to manage it. First, the public official can recuse and file the commission's approved conflict of interest form. Or two, the public official can ask the neutral reviewer to help determine whether the public official can participate. So you may be asking, who is the neutral reviewer? Well, under the commission's rules, a government body can and should designate the neutral reviewer in that government body's policies or rules. However, if there is no policy or rule, the Ethics Commission's rules identify a default neutral reviewer. For the legislature, it is the remaining members of a legislator's chamber or committee. For legislative employees, it is the legislative employee supervisor. For members of the governor's cabinet, the neutral reviewer is the governor's designated ethics officer, which is the governor's general counsel. If a public official is appointed, the neutral reviewer is the person who appointed the public official. And if no policy, rule, or default rule applies, the public official must make the neutral reviewer determination on his or her own and report it within 7 days. So we have 2 polls for step 3 to help you exercise your knowledge of this step. So let's start with poll 3. Poll 3. Public official John Dutton disclosed a potential conflict of interest prior to taking action or making a decision in a matter. What must he do next under the commission's rules? Vote, resign, recuse and then ask the neutral reviewer to help, or recuse or ask the neutral reviewer for help. Submit your answers and I'll give you a little bit of time to do that. About 10 more seconds and then we'll reveal the answer for this poll. Okay, let's close the poll and see how everybody responded. So 1% of you said vote, 0% of you said resign, 16% of you said recuse and then ask the neutral reviewer to help, and 82% of you said recuse or ask the neutral reviewer for help. So the correct answer is what the majority picked, recuse or ask the neutral reviewer for help. Again, under step 3, the public official has 2 options, recuse and file the form, or ask the neutral reviewer for help. If you recuse before you're reaching out to the neutral reviewer, you're already recused from the matter and really have no reason to ask the neutral reviewer to help at that point. So let's do poll 4 for step 3. Poll 4. Animal Rights Commissioner Jessica Rabbit wants to ask the neutral reviewer for help. She is a member of the governor's cabinet. Who is the neutral reviewer under the commission's default rule? The governor's ethics officer, the majority leader of the Senate, the governor, or Ms. Rabbit herself. So take a little bit of time and respond to that one. Okay, we'll do about 10 more seconds if you still want to get an answer in. Okay, let's close the poll and see how you responded. 86% of you said the governor's ethics officer, 4% said the majority leader of the Senate, 8% said the governor, and 1% said Ms. Rabbit herself. So the correct answer is the governor's ethics officer, the first one, which again, the majority of you got correct. I will note the governor was also an option, but again, the question identified Ms. Rabbit as a member of the governor's cabinet, so she falls under the default rule for the governor's ethics officer to be her neutral reviewer. So moving along to step 4. So let's assume Ms. Rabbit asked the governor's ethics officer for help. If the public official asks the neutral reviewer for help, the neutral reviewer has 5 factors to evaluate. Those come from North Dakota Administrative Code section 115-04-01-03, subsection 7. If you don't have time to look those up right now, we have summarized those for you on the board. The 5 factors are: 1, weight and deference must be given to the requirement that the public official perform the duties of his or her position, including the duty to vote. 2, recusal or abstention should only occur where the potential conflict of interest would materially affect the independence of judgment of a reasonable person in the public official's shoes. 3, the neutral reviewer shall consider any North Dakota law that would preclude the public official from recusal or abstention. 4, there's a presumption that a public official does not have a disqualifying conflict of interest if the public official does not get any personal benefit bigger than a member of the general public or any general business, profession, occupation, or group affected by the matter. And 5, the neutral reviewer must also consider any guidance issued by the Ethics Commission, including informal guidance, advisory opinions, rules, standards, and precedent. So moving into step 5, once the neutral reviewer evaluates the 5 factors from the commission's rule, the neutral reviewer must make a determination. The neutral reviewer determines whether a potential conflict of interest equals a disqualifying conflict of interest requiring recusal. The neutral reviewer may request further information from the public official to help make the determination when they're doing the evaluation back in step 4. If the neutral reviewer is a group, like a committee or legislative chamber, the public official with the potential conflict of interest may not participate in the neutral reviewer's decision. Because the public official with the potential conflict of interest cannot participate, under the commission's rules, the quorum requirement for the group is reduced to make the conflict determination. The body would act as if the public official with the potential conflict of interest is not a member of the group for that determination vote. The neutral reviewer must also comply, of course, with North Dakota's open meeting laws for the determination. If you are unsure whether it should be an open or executive session if it's during a meeting, please consult the attorney for your governing body. So at step 5, there's 2 options for the neutral reviewer to make. First, the neutral reviewer can determine no disqualifying conflict of interest exists. The public official may participate in the matter after hearing the neutral reviewer's determination. The other option, option 2, the neutral reviewer can determine a disqualifying conflict of interest exists. The public official must recuse him or herself after hearing the determination under the commission's rules. Under the commission's rule, the decision to recuse is ultimately left up to the individual public official who has a potential conflict of interest. However, if that person fails to recuse after the neutral reviewer determines a disqualifying conflict of interest exists, it creates the potential for an ethics complaint. However, the commission will not find an ethics violation when 1, the public official consults with and adheres to the neutral reviewer's decision, 2, the public official acts in good faith, and 3, the disclosed material facts surrounding the potential conflict of interest are substantially the same as presented in an ethics complaint. So let's move to another poll. This will be poll 5. Bring it up here for you to respond. Poll 5. The neutral reviewer determines board member Indiana Jones has a disqualifying conflict of interest in a matter. What happens next? Mr. Jones should participate in the discussion and recuse before voting. Mr. Jones should recuse himself immediately. Mr. Jones should vote. Mr. Jones should argue with the neutral reviewer. Please submit your response and we'll take a look here in a minute. Give you a few more seconds here. Okay, let's close the poll and see how you all responded. So the majority of you said Mr. Jones should recuse himself immediately. That is the correct answer. After hearing the neutral reviewer's decision, the public official should recuse under the commission's rules if there's a disqualifying conflict of interest. So let's move into step 6. This is probably the most often forgotten about step because it's easy to forget, but step 6 is also very important. Once the public official recuses or hears the neutral reviewer's decision, he or she must fill out and file the Ethics Commission's approved conflict form. The form is available on the Commission's website, ethicscommission.nd.gov. The form must be filed with the public official's own governing body and the Ethics Commission. The minutes of the governing body must document any recusal if one occurs. An important caveat to this is legislators participating in floor sessions and legislative committees do not need to file the form. This is according to Ethics Commission Advisory Opinion 23-01, which you will hear me discuss in detail later. But quickly, journal entries and video recordings the Legislative Assembly uses satisfy the disclosure requirement. The Legislative Assembly also has a conflict tab on its website listing the disclosures like they would have if they had to file the form. An important consideration, though, is this exception does not apply when legislators serve on executive boards like the PERS Board, the Emergency Commission, and the State Investment Board. And that's because those executive boards don't have the same mechanism in place like the Legislative Assembly does for journal entries, video recordings, and a list of disclosures online on their website. So let's take an overview of the 6-step process and do another poll here. But again, let's go through the flow chart first. First, prior to taking action or making a decision in a matter, public officials must identify any potential conflicts they may have. Then they move into step 2. On the record, if possible, declare the potential conflict of interest. Provide enough facts for others to understand the potential conflict. Then move into step 3, where the public official has 2 options. Either recuse and fill out and file the commission's approved conflict of interest form, or ask the neutral reviewer for help. Then in step 4, if you ask the neutral reviewer for help, the neutral reviewer will take over and evaluate those 5 factors from the commission's rules. Then in step 5, the neutral reviewer will make a determination, either determining a disqualifying conflict of interest exists. At that point, the public official will recuse, or the neutral reviewer can determine no disqualifying conflict of interest exists. At that point, the public official may participate. Then in step 6, in either determination scenario, the public official shall fill out and file the Ethics Commission's approved conflict of interest form. So let's do a poll overviewing the whole 6-step process. And it happens to be poll 6. Commissioner Julia Roberts identifies a potential conflict of interest, declares it on the record, and requests the neutral reviewer determine whether she can vote in the matter. The neutral reviewer determines Commissioner Roberts can vote. Commissioner Roberts follows the neutral reviewer's advice and votes on the matter. Has she followed the 6-step process correctly? Yes, she completed all 6 steps. Yes, she followed the neutral reviewer's advice. No, she should make her own determination, or no, she forgot to file the form. So please submit your response and we'll take a look here in a minute. Give you a few more seconds to respond. And let's close the poll and get the correct answer. So it looks like most of you had the correct answer. No, she forgot to file the form. That is correct. Please don't forget about step 6, filing the form. She did follow the neutral reviewer's advice, and she would have almost completed all 6 steps. I see some of you responded that way, but she did forget to file the form. So let's move on and talk about the legislative conflict rules and the Commission's analysis in Advisory Opinion 23-01. The legislature has its own rules dealing with conflicts of interest. Again, we detailed this history in our first webinar. If you haven't had a chance to go and watch that, please do. It's available on our YouTube channel. But the legislature's rules are found in House and Senate Rules 321 and 322. The Commission's rules state any entity subject to the Commission's conflict of interest rules, quote, may adopt conflict of interest rules that are more restrictive, but may not adopt conflict of interest rules that are less restrictive. Again, you will hear a lot about Advisory Opinion 23-01 in this section. The Commission stated in that opinion, the Commission's and the legislative rules can be harmonized. The legislature continues to support having a conflict of interest provision in its own rules. During the 2023 session, the legislature made a new statute, North Dakota Century Code, section 54-66-18, which requires it to adopt conflict of interest rules. Again, the Commission analyzed the language of the legislative rules at length in Advisory Opinion 23-01 and found the rules could be harmonized. The process is almost mirrored in the legislative rules and the Commission's rules. So let's break down the legislative process according to the Ethics Commission's Advisory Opinion 23-01. First, a legislator will identify potential conflicts in a bill or resolution. 2, the legislature will declare the potential conflict to the chamber of which he or she is a member and is automatically recused from voting until the neutral reviewer makes a determination. The legislator must provide enough facts for the other senators or representatives to understand the potential conflict that they must consider. At step 3, the rules operate so the legislator automatically asks the neutral reviewer for help, and that legislator will remain recused until the neutral reviewer makes a decision. At step 4, the neutral reviewer, the remaining senators or representatives, makes the neutral reviewer determination. They must use the 5 factors in the Commission's rules to make the determination if a disqualifying conflict of interest exists. At step 5, the legislator follows the neutral reviewer determination, either remain recused or vote on the issue if allowed by the remainder of the chamber or committee. At step 6, again, you'll note no form needs to be filed when the potential conflict is disclosed during the legislative process, because journal entries and video recordings satisfy the disclosure. Again, if it's not in a legislative committee or on the floor, then the form must be filed because these 2 factors are absent. So there's two qualifiers to note about the legislative rules. First, the legislature uses the term personal or private interest, which means a potential conflict of interest. However, personal or private interest is defined in the legislative rules as an interest that affects the member directly, individually, uniquely, and substantially. You'll note from the first webinar we discussed this, but this definition was added in 1981 because, quote, members expressed concern over confusion among legislators related to instances when a conflict should be disclosed. Members expressed the opinion that there is a difference between a specific conflict of interest as compared to a remote conflict because a legislator is a member of a larger group, unquote. At the time, the legislature interceded that this language serve as a guideline for individual legislators in deciding whether to disclose an interest in a measure. Directly, individually, uniquely, and substantially, however, is a term of art that is not thoroughly defined somewhere else. Therefore, in Advisory Opinion 23-01, the Commission encouraged legislators to look to the Commission's definition of a potential conflict of interest. The Commission said both sets of rules, quote, required disclosure when a member has a significant financial interest in the outcome of a measure or bill that is unique to that member, when a member has received a gift from a party, or when a member has a relationship in a private capacity with a party, unquote. The other qualifier is number 2, the legislative rules required the neutral reviewer determination to take place, quote, without debate. The Commission acknowledged the rules required the neutral reviewer to make a determination in Advisory Opinion 23-01. However, the Commission said, quote, the best practice is to allow an opportunity for meaningful evaluation of the member's potential conflict of interest. The caveat of the legislative rules is that each individual legislator must do the neutral reviewer evaluation on his or her own and in silence when acting as the neutral reviewer. The Commission maintains allowing discussion would allow legislators to consult one another to make the determination, make the process more transparent, and establish a thorough record. With the benefit of discussion, the public would then be able to openly hear and see what is being considered for the neutral reviewer determination. So now that we've outlined the process in the legislative rules according to Advisory Opinion 2301, let's walk through it with a flowchart. At step 1, prior to taking action or making a decision in a matter, legislators identify any potential conflicts they may have. At step 2, on the floor, declare the potential conflict of interest. Provide enough facts for other legislators to understand the potential conflict. Here at step 3 is how it differs. The legislator is then automatically precluded from voting. The neutral reviewer, all the other legislators in the body or committee will help. At step 4, the neutral reviewer looks to 5 factors in North Dakota Administrative Code section 115-04-01-03 sub 7. The neutral reviewer then at step 5 can make one of 2 determinations. The neutral reviewer can determine a disqualifying conflict of interest exists. The legislator will then be recused. The neutral reviewer can also determine no disqualifying conflict of interest exists. The legislator may then participate. Again, at step 6, no form filing is required because the legislative process automatically takes care of that. So let's test your knowledge of the legislative rules with a poll. Poll 7. Senator Lucy Ricardo identifies a potential conflict of interest in a bill and declares it on the floor of the Senate. The remaining members of the Senate automatically analyze the potential conflict, acting as the neutral reviewer. By a majority vote, they determine Senator Ricardo's potential conflict of interest creates a disqualifying conflict of interest, and she should not vote in the matter. Senator Ricardo follows the neutral reviewer's advice, remains recused, and abstains from voting in the matter. Has the 6-step process been followed correctly? Please submit your response. Take about 15 more seconds here to see if you want to get a response in. Okay, I'm going to close the poll and we'll take a look here. So 94% of you said yes, and 6% of you said no. Let's reveal the correct answer. The correct answer is yes. Because it took place during the legislative process, again, no form needs to be filed. The Ethics Commission in Advisory Opinion 23-01 stated the video recording and journal entries the Legislative Assembly uses satisfies the form filing requirement. So at this point, I'm going to hand it back over to Rebecca, and she's going to talk to you about the quasi-judicial bias rule. Rebecca?
Great. Okay, let's dig into our quasi-judicial bias rules. So when we think about quasi-judicial bias rules, or appearance of bias rules, as they can be called, one of the first questions that we have is, what is a quasi-judicial proceeding? It has a somewhat funny name, and it definitely has a legal name. So let's talk about it briefly. A quasi-judicial proceeding resembles a court proceeding, but it doesn't take place in court. Usually it takes place within an executive administrative agency. Public officials will listen to arguments, they'll look at evidence, documents, interviews, and they'll make a decision on the facts that are before them. Some examples include disciplinary actions before licensing boards. Many boards and commissions across the state do this. Public Service Commission permit proceedings, hearings before the Office of Administrative Hearings, and then complaint proceedings before the Ethics Commission. So Article 14 of the Constitution requires that both the legislature and the Ethics Commission pass either legislation or adopt rules regarding the appearance of bias in what we call quasi-judicial proceedings. In the summer of 2022, shortly before the Commission adopted conflict of interest rules, the Commission adopted quasi-judicial appearance of bias rules before it made the conflict of interest rules. These quasi-judicial bias rules help to manage any appearance of bias in a quasi-judicial proceeding. The process for disclosing or managing that that appearance of bias in the quasi-judicial proceeding is similar to the process for disclosing a conflict of interest. There are, however, three key differences, and we're going to talk about those, and then we're going to walk through a flow chart. So one, the quasi-judicial process could apply to more people than the conflict of interest disclosure process. Article 14 states, quote, directors, officers, commissioners, heads, or other executives of agencies shall avoid the appearance of bias and shall disqualify themselves in any quasi-judicial proceeding in which monetary or in-kind support related to that person's election to an office, or a financial interest not shared by the general public, creates an appearance of bias to the reasonable person. Therefore, under this rule, or under Article 14 of the Constitution, directors, officers, commissioners, heads, or other executives agencies are subject to the Ethics Commission's authority or jurisdiction, and subject to this quasi-judicial rule. This slightly expands the jurisdiction of the Ethics Commission in quasi-judicial proceedings. This then could include executive branch employees if they are acting as a director, officer, commissioner, or head, or other executive in a quasi-judicial proceeding. Otherwise, outside of quasi-judicial proceedings, the Commission only has authority over lobbyists, candidates for office, and public officials, which are legislative employees and not an elected or appointed officials of the executive and legislative branches, not executive branch employees. Second, the quasi-judicial appearance of bias rules consider not only potential conflicts of interest, but also campaign support that has been provided to the public official or the public official's campaign. This includes either monetary or in-kind support. The third distinction between the quasi-judicial appearance of bias rules and the conflict of interest disclosure rules, instead of determining whether the potential conflict or campaign support is a disqualifying conflict of interest, the determination is whether it creates an appearance of bias to a reasonable person. The individual who has the potential conflict or who has received campaign support or the neutral reviewer must make this determination. Under the Commission's rules, an appearance of bias to a reasonable person means that the interest in question could create in a reasonable person's mind a perception that the director, officer, commissioner, head, or other executive's ability to carry out quasi-judicial responsibilities impartially and without bias is impaired. The Commission has outlined 4 factors to consider whether the potential conflict or campaign support, remember monetary or in kind, creates an appearance of bias. 1, whether the potential conflict or campaign support involves a party to the proceeding. This comes in play with adversarial proceedings in particular. The advice number 2, the issue involved in the quasi-judicial proceeding. 3, if there are any other factors known to the director, officer, commissioner, head, or other executive that creates an appearance of bias. And 4, the impact of the campaign support, including, these are other considerations, the size of the support, whether it's financial or otherwise, the degree of involvement in the campaign, and whether the campaign support is within the current or immediately preceding election cycle. So with that overview, let's go to a poll to test your knowledge on this. All right. You should see that popping up on your screen here. Poll 8. Dr. Derek Shepard serves on a licensing board and a complaint has been filed with the board against his wife, Dr. Meredith Gray. Dr. Shepard declares the potential conflict of interest at a board meeting on the record. He asks the neutral reviewer to weigh in. What must the neutral reviewer determine? 1, if Dr. Shepard can remain objective. 2, if the complaint is frivolous. 3, whether an appearance of bias to a reasonable person exists. Or 4, whether Dr. Gray is okay with her husband participating in the complaint matter. So we'll give you just a minute here to answer that question, and then we'll reveal the answer and test your knowledge. I'll give you just another few seconds here to submit a response to that poll question. right? I'm going to go ahead and close the poll. So it looks like almost everybody, 98%, said the answer was whether an appearance of bias was present to a reasonable person exists. 2% said that if the question for the neutral reviewer to consider is whether Dr. Shepard can remain objective. So let's go and talk about the answer. So the answer, as nearly everybody got correct, is whether an appearance of bias, whether there is an appearance of bias to a reasonable person that exists. That is the question, or that is the answer. So let's, after that poll, let's do a quick review. We have another flow chart for you that helps us walk through the 6 steps. Now you can see in these that there's this slight difference between the conflict of interest process, but what's going to be great is that we're going to make these available to everybody afterwards so that you can use these flow charts for reference. So if we look at the top of the flow chart, our first step, number 1, is prior to taking action or making a decision in a quasi-judicial matter, the individual must identify any potential conflicts of interest or identify any campaign support that has been received. Next, you move to 2, on the record, if possible, the individual should declare the potential conflict of interest or describe the campaign support received. They need to provide enough fact for others to understand the potential conflict of interest or the scope of the campaign support. Step 3, which is broke down into 2 sections or 2 flows here, is to either recuse or ask the neutral reviewer for help. Step 4, and if you recuse, you go ahead and fill out and file the commission's approved quasi-judicial form. If you ask the neutral reviewer for help, you move on to step 4. The neutral reviewer then reviews the 4 factors to determine whether the potential conflict of interest or the campaign support creates an appearance of bias to a reasonable person. Then we move on to step 5. The neutral reviewer may determine an appearance of bias to a reasonable person exists. If an appearance of bias to a reasonable person does in fact exist, the individual must recuse him or herself. If the neutral reviewer determines no appearance of bias to a reasonable person exists, the individual may participate in the quasi-judicial proceeding. And last, our step 6, which we can't forget about, but we tend to, is the individual must fill out and file the Ethics Commission's quasi-judicial form. That form, again, is available on the website. So what do you do when someone needs to recuse from a quasi-judicial proceeding? The Ethics Commission's rules include a substitution provision. It states that a governing body shall follow North Dakota law when a substitution is needed for a vacancy in a quasi-judicial proceeding due to a recusal for following the Commission's rules. If no law exists addressing the vacancy, the governing body can adopt a policy for substituting officials for quasi-judicial proceedings. So that wraps up. We talked about the potential or the conflict of interest rules. We reviewed the legislative rules, and we gave a brief overview on the quasi-judicial rules. So now we're going to see if anybody has questions and then address some of those questions. Before we get to questions, I wanted to let you all know that both the slides and the recording will be made available early next week to everybody who's registered. Also, throughout the presentation today, there were several flowcharts outlining the steps, the 6 steps that we had for each of those different sets of rules. Those handouts for the flowcharts, we've created handouts for those, and we're going to make those available on our website. Also, Commission staff has created what we call a short refresher video. This reviews the content from today, but in a much shorter time frame. So this is able to be used as a quick reference guide, or if you need to pull it up on your phone, if you have a question. Basically, today is the basis, and then we're providing you guys with some additional materials. After our webinar, you will receive an email with a link to the recording and as well as all of our handouts and refresher video. Also, just a quick note on advisory opinions, and I see we're really running out of time, but I want to do that. If you have questions about the application of one of these rules to a particular circumstance or a situation, the Commission has authority to issue advisory opinions to address those. More information on requesting an advisory opinion is available on the Commission's website. You can also feel free to shoot either myself or Logan an email. So with that, I'm actually going to scoot over and let Logan kind of move in so I can check the chat for some questions. We've already gotten a few that I've written down. So the first one is, how do we access either the quasi-judicial form or the conflict of interest form? Logan, you want to let us know?
So both forms are available on our website. You bring up ethicscommission.nd.gov. You'll note that there's 4 or 5 bubbles under our rotator, and you can click those. There's one for the conflict of interest process, and there's one for the quasi-judicial process. Select the one you need, and it'll take you right to the information you need.
Perfect. Okay, so the second question that we have, and we get this a lot, didn't come up in the chat, but we do get this question, is how in the world do I file this form? You say that that's an important part, not to forget to do that. How do I do that?
Sure. So the form will actually walk you through the process, but at the end or somewhere on there, it says to submit it to our email, ethicscommission@nd.gov. Now, an important caveat is this will probably be changing in the near future as the Commission is working on electronic forms where you will just go to our website, import the information, and it will go directly to the Commission once you hit submit.
Great information to keep in mind, okay? Next question that has come up is, what if you don't? You said in the presentation that you need to file the form before taking action. But if you're in a meeting and there's decisions that need to be made, what do you do if you don't have time to file the form before taking action?
Sure. So I think the Commission's rules contemplated that, and they give you 7 days to file the form to satisfy the 6th step, the form requirement.
Yes. So when there's an emergency, or when there's not even an emergency, but just action needs to be taken quickly, right? Then there's that 7-day provision. Perfect. The other question that came up is the forms that are filed with the Commission, whether it's the quasi-judicial bias form that discloses that appearance of bias, or the conflict of interest form, are those forms open to the public?
Absolutely. So if somebody submits an open records request, we respond to those and we will provide you the form. Sometimes the forms do include confidential information, so we make sure to screen those for that before we provide it in response to a request. But absolutely, if anybody wants to request those, they are available.
Okay, I'm going to just quick do a check of the chat for any questions, other questions that we may have. And if we don't have any, as I said before, information will be emailed out to you that will come from Alicia in our office. And if you have any questions, feel free to reach out to myself or to Logan or to the Ethics Commission. We can certainly guide you to materials that could help with any of those. And yes, you will get a refresher video, which is super short, but outlines that 6-step process. And you'll also get access to those flowcharts that help. Just that visualization usually helps with many questions. So again, I want to thank everybody for attending today. Thank you for attention. I know that this is a lot of material in a short amount of time. So we really appreciate everybody for joining us today. And we look forward to doing this again. And we are going to come back with another Dakota Dilemma webinar this summer. So look forward to that. We'll send out emails when we have a date. All right, thank you, everybody.